Welcome to the Synchrony Law vlog. I'm Suzette Squires, and in this vlog I'm going to look at how employers can carry out fair and proper investigations when allegations against employees concern criminal issues or regulatory breaches. Whenever an employee is suspected of misconduct, an employer will need to carry out an investigation to establish the facts and determine whether further action is necessary. Whilst this may sound straightforward, it can be a delicate process, and a flawed investigation can undermine a disciplinary process and leave an employer vulnerable to legal action. Employers should be mindful of their own internal investigation procedures and the extent to which they may be contractual. They should also consider the principles of fairness set out in the ACAS Code of Practice and supplementary guidance for conducting investigations. How much investigation is required will vary from matter to matter, but a complicated case may take weeks to investigate properly. The investigator should be independent, sufficiently senior, and ideally not the same person who will have a decision-making role in any future disciplinary action. This will normally be someone internal, but where the matter involves criminal or regulatory issues, it may be appropriate to appoint an external lawyer. It won't normally be feasible for an employer to wait for the outcome of any regulatory or criminal proceedings before progressing an investigation, as this could take months or even years. An investigatory meeting should be held with the employee as soon as possible, and they should be given reasonable time to prepare. Whilst there is no statutory right for an employee to be accompanied at the meeting by a work colleague or trade union rep, some employers allow this. In serious cases, a decision may be taken to suspend the employee whilst the investigation is carried out, and this will normally need to be on full pay. There may also be a requirement to notify the relevant regulator where the employee works in a regulated environment. At the end of the investigation process, the investigator will need to confirm whether they believe the employee should be invited to a disciplinary hearing. Whilst the investigator can take advice from HR, this decision needs to be their own. They will also need to consider whether the alleged wrongdoing needs to be reported to the authorities or appropriate regulatory body. If you'd like specific advice about how best to conduct a workplace investigation, please do not hesitate to contact us.